Thank you, everyone, for joining us for this presentation over the Merit Systems Protection Board. I know we have a lot of people joining us today because I know this is a very timely presentation given everything that's happening in the federal government. So I'm glad to be presenting to each and every one of you regarding the Merit Systems Protection Board and this agency that was probably not as well known to some people before this year. I'm happy to go over it and discuss the details of this. As you see on our screen, this is a little bio about myself. I am a managing partner here at Tully Rinckey. I am also the chair of the Federal Practice Group. As you can see in my bio, I've litigated it in cases all over the country, including in DC, Maryland, Texas, and I continue my practice here today at Tully Rinckey. As you can see, there's more of my bio on the screen. As I also just want to say before we get started on this presentation, that this is meant for guidance over the Merit Systems Protection Board on filing appeals, on who has jurisdiction to file an appeal. But it's not meant to replace any specific guidance on any legal matter you may have, any notice you may have received. And if you'd like that specific guidance, you should contact an attorney to go over the specific details of your case. But again, this is an overview of the Merit Systems Protection Board, what it is, what it pertains to, who could file there, but it's not meant to replace any specific advice or guidance on your legal case. So with that said, we could move forward. So just an overview of what we're going to learn today. So like I said, we're going to learn about what is the Merit Systems Protection Board. The MSPB is the acronym. What appeals does the MSPB have? What jurisdictions does the MSPB have to hear appeals? Who could appeal and how to appeal? And what actions are appealable to the Merit Systems Protection Board? And then we're going to go over the different stages of an MSPB appeal and just the benefits of having a representative through the process. Like I said earlier, I know this is a timely presentation given that there are a lot of reduction in forces happening. I know that was most of our questions, so I'll try to focus on that as well as I go through the process and just the steps there that you or people you know that work for the federal government could take regarding those actions. So just what is the Merit Systems Protection Board? Well, the Merit Systems Protection Board is a independent federal administrative agency that was established under the Civil Service Reform Act of 1978. The primary purpose of this agency is to protect federal merit principles that protect the federal employees, such as in the removal process of employees, or even in the hiring process in some instances. There are federal regulations that protect federal employees in their positions and for adverse actions that specifically give due process to those employees. And the Merit Systems Protection Board's role is to confirm and adjudicate whether those employees were given fair due process and whether those employees, those actions taken against those employees were adequate and proper. It offers guidance to agency supervisors to help create that diverse workforce and effectively manage that workforce. The federal regulations could be found in the Code of Federal Regulations. Specifically, the jurisdiction is found in 5 CFR 1201. There are multiple regulations that outline where the board has jurisdiction over employees. Now, the board has jurisdiction over additional claims, specifically claims brought by the Office of Special Counsel or through the Office of Special Counsel by employees. And the Office of Special Counsel is another agency that that hears whistleblower disclosure claims, prohibited personnel practice claims that some employees may be able to file through what they call individual right of action from the Office of Special Counsel. There are additional jurisdictional additional claims that the board has jurisdiction over, and including claims against administrative judges, and claims involving the SES, senior executive service employees. The board's makeup is, the board employs administrative law judges that could hear claims and hold hearings over claims. These are judges that will adjudicate cases. And then, as we'll talk about soon, the employees can then, if needed, file petitions for review to the Mayor Assistant Protection Board, which is made up of a panel of members. Currently, as you may have seen in the news, there has been, removal of a board member and a retirement of a board member that has removed quorum from the board, which means that the board officially can't issue decisions, but those petitions for review could still be filed with the board, and administrative law judges can still review and rule on cases as well. So I guess the point is that you could still file an appeal with the Mayor Assistance Protection Board over those adverse actions that you're receiving, including the reductions in force. And there's still administrative law judges there to hear those appeals. So for the next slide, as far as jurisdiction, so this slide covers all the actions that the MSPB has jurisdiction over. And I guess we'll just backtrack on that. It covers a summary of the actions. There's many actions probably not even listed at this page that the MSPB may have jurisdiction over, but just as far as general actions, the MSPB does have jurisdiction over. The reduction in grade or removal actions. Reduction in grade is, could be known as a demotion. A removal action, that the board has jurisdiction over those type of actions. Now, those reduction in grade or removal actions can be based on unacceptable performance. The board also has jurisdiction over those actions that they're based on misconduct. As far as misconduct actions, the board also has jurisdiction over suspensions over 14 days and more. So over more than 14 days, excuse me. And that's an important distinction because you may receive a suspension for 14 days, but the board may not have jurisdiction over that action. And in addition, furloughs for 30 days, the board has jurisdiction over as well. Now, the board, the agencies have to prove that these actions will promote the efficiency of service, as we'll get into later as far as the burden of proof is concerned. As I've mentioned a couple times now, and I know it's important here, the board also has jurisdiction over reduction in force actions, as the reduction in force notices are indicating that the board does have jurisdiction to hear those actions as well. There are other actions that the board does have jurisdiction over that are listed on the screen, including suitability determinations. If you're in your probationary period, the board still may even have jurisdiction over your claim if you could show that it was based on a marital reason or political reason. There's the board jurisdiction over your SARA matters. Those are matters involving military service. There's board jurisdiction over individual rights of action that concern disclosures of prohibited personnel practices and whistleblower retaliation. There are board jurisdiction over veterans preference issues as well. So like I just said, there's a lot of actions that the board does have jurisdiction over. There are actions that the board does not have jurisdiction over. That's not listed here. For example, a reprimand, perhaps the board probably won't have jurisdiction over that action. If you are a probationary employee, unless you're able to show that it's the probationary termination was based on a partisan political affiliation or a marital purpose, then the board likely does not have jurisdiction over that action as well. And what may happen is after you file an appeal with the Mayor Assistance Protection Board, they will issue an order determining whether or not the board does have jurisdiction. And just to be clear, I keep on saying the board. Whenever I do use the board, I'm referencing the Merit Systems Protection Board. That's often an acronym that people do use for the Merit Systems Protection Board, or MSPB. But again, these are regular actions that employees may bring to the MSPB, to have their appeals heard. And we have another slide on just jurisdictional actions, or the board's jurisdiction over actions that are listed here. A number of actions are not utilized frequently, but we're just trying to be as comprehensive here. We have failure to reinstate a former employee after service under the Foreign Assistance Act. For instance, there are a number of actions regarding furloughs of SES employees. Indefinite suspensions, even, because those are more than 14 days. Disability retirement matters as well, or actions that can be brought to the MSPB if the Office of Personnel Management has denied those disability retirement applications. So those are additional actions that employees could take to the Merit Systems Protection Board to have a administrative law judge review and determine whether or not the action taken by the government was wrongful or not. So and these are, again, just additional actions. I'm not going to cover every single one of these because I don't know if they pertain to everybody that's attending this presentation. But again, these are just comprehensive actions that the board does have jurisdiction over as far as additional former employees or current employees that are seeking to have their rights heard at the Merit Systems Protection Board. But getting into just the process of filing an MSPB appeal, if you are covered employee, I think most instances, if not all instances, an appeal must be filed within 30 days of the effective date of the decision or letter. And if we could just go to the next slide, please. Thank you. So like I was saying, an appeal must be filed within 30 days of the effective date of the decision. And that is important because you may receive a letter. For example, the RIF notices that have been going out have gone out to employees, and those are dated perhaps today or last week, but the effective date is not for 30 or 60 days from now. So the deadline to file that appeal doesn't run until the effective date happens. And if you file before the effective date, the MSPB may deny the appeal. You may be able to file again after the effective date, but the MSPB probably will deny the appeal as premature. So it's important to wait and know the effective date of the adverse action. To file the appeal, that is done online. And that's done due to an MSPB portal that actually they renewed last year to allow employees to file actions. That's primarily done by completing a form, what's called a Form 185, online at mspb.gov. And it's pretty self-explanatory on how to find the form and what to fill out, but we actually will go through it here. So this is what the form looks like. It is several pages long, but as you can see, the form it does request that you provide your personal information as far as your name, your address, your location, your contact information, so then MSPB can get in contact with you. You'll need to list your agency or former agency's name. You'll need to list your type of employment and the type of employee you were. You also have to list your grade level, at least your last grade level, your last position, your last duty station, your length of government employment, and whether you're entitled to veterans preference or not. Importantly, in box 11, you want to make sure you check whether you want a hearing or not. I advise most of my clients to check yes, they want a hearing, although you may be able to adjust that after you file your appeal. You just don't want to forget about it. It's better to just check it at the beginning, because if you don't and you forget to adjust it, then you may not be entitled to a hearing. And a hearing is an actual hearing before an administrative law judge where you'll be able to testify under oath regarding your claims and have certain agency witnesses testify regarding the action against you. So it's important if you want to be heard verbally to a judge, it's important you check that box saying yes, that you do want a hearing. That gives you that further opportunity for an administrative law judge to hear you and to receive your evidence. Now, if you don't want a hearing, if you don't want to be heard verbally, that's okay. You could still continue your action. And what administrative law judges will do is allow you to submit a written brief or whatnot explaining why the action against you was wrongful. But I always find it is helpful for a judge to hear and see my client, especially whenever there is any kind of credibility issues going on, or it's one person saying that my client took an action when they really didn't. So I always advise my clients to check that box, yes, but it's important for you to not skip over that box and to check it. And on the next page, you are then completing what the action was. These are kind of some of the actions that we went over. There's the removal, there's a reduction in grade. If that was the action taken, you would click that. If you were removed, you would check it. If it's a demotion or reduction in grade, or a RIF, a separation due to a reduction in force, then you would check that box as well. And then you would have to click the date of the decision, the effective date of the decision. And you see that box 14. You also click when you received it as well. You actually type it in as well. There is a box here regarding whether or not you engage in alternative dispute resolution. In most cases, this isn't really applying. There are cases where you are able to get an agreement in writing to extend that deadline to participate in ADR. And if you do, you've got to make sure you have that in writing because you have to attach it to your appeal. The next box, box 16, is also important because this is where you have to explain why the action taken against you was wrongful. And we, as our law firm, when we're filing these appeals on behalf of federal employees, we're always including what we call a continuation sheet, a sheet explaining, because we don't just use it, we don't just type everything in that box. We'll include on an additional sheet all the reasons why the action was wrongful, to include, whether or not the charges actually happened, whether or not the agency could promote the efficiency of service, whether the penalty that's being proposed is too severe, whether there was any due process issues with the removal of our client. In addition, whether we're asserting the action was taken retaliatory or discriminatory, we're including all those reasons. And we're also attaching any pertinent evidence, and then also we're attaching the actual notice as well for the removal, reduction in force, whatever the action is. So I guess just to rewind there, it's important obviously to fill out every single box here, but focusing on checking the box of yes if you want a hearing or not. And then, including the correct effective date of your action, the correct action that you're appealing, and then just describing in detail why it's wrongful. And just to elaborate on that explanation, and I'll probably get to this later as well, but you should explain why the action is wrongful in your MSPB appeal. Now, you won't necessarily be limited to that explanation if you feel like you left something out. If you're going with something at the last minute and you're just trying to get it filed, the judge will likely allow you to provide more explanation, especially if you ask for a hearing. The judge will likely allow you to provide more explanation about why the action is wrongful. But it's important to provide that at the beginning as well, because the government will have a chance to respond to your appeal and submit its file and say why the action was appropriate. So it is important to provide that evidence in your MSPB appeal. So on the next few pages, these pertain to whether or not you're appealing those additional actions we were referencing. So I mentioned, retirement actions or decisions that are appealable to the board. As you can see there, and actually in part 3, those are actions that can be appealed to the board. Individual right of actions also listed here, and a USERRA actions also listed here. As I said earlier, an individual right of action is an action that's taken after the Office of Special Counsel has issued a determination letter on a whistleblower complaint that you may have brought there. And then the Office of Special Counsel will issue a letter and provide you a length of time to file your MSPB appeal. And so that's what that box is for. And then the USERRA matter is what this box is for, as far as just detailing whether or not you are filing a matter regarding military service. Now with USERRA matters, you can go through the Department of Labor to initially file your complaint there. I don't think you're required to, but you could file with the Department of Labor. So that's what it's asking, is if you did, and to provide details on your filing. And on the initial box that deals with grievances and whether or not you filed a grievance under a negotiated grievance procedure by a collective bargaining agreement, and detailing, providing that detail whether you did and the date and what agencies you did, and attaching that grievance as well. And so these pages are just asking for additional information for the MSPB to be able to process your case. They're ensuring with this information that your appeal is timely. They're also ensuring that there's no reason why your appeal should be dismissed because it exists in another forum, or you've already received relief, perhaps through a grievance. Perhaps if you've already received relief through that, then the MSPB may find that this is a moot issue. But it is, again, the purpose is to just provide the MSPB as much information as possible about where you filed and the dates of the filing, and to just confirm there's jurisdiction over your appeal. So the last few pages of an MSPB appeal form, again, it's a Form 185 found on its website, is to just confirm whether you're represented by an attorney or a representative. Then you have to provide that information. If you're not at this time, at the time you file your appeal, you're not limited. You're not precluded from obtaining an attorney, even during the course of your appeal, even before hearing. This is just indicating whether you have a representative or not. And then the certification there is just you signing the form. Please make sure to sign the form certifying that this is the information. And when you sign the form, again, like I mentioned, you submit it on the portal. We gave you the MSPB website. On the website, it shows where where to put the form in. You have to click through several different options, and you may have to provide some of the information on the form that you already provided. But I think it is self-explanatory. Sometimes, as with a lot of government servers, it does take a while for the appeal to actually get processed. As far as just clicking through and things, it may run a little slow, but in most instances, after you click submit, then you're going to get an automatic notification to the email address that you put in to the MSPB form and on the portal, showing that it was submitted. And then usually within a day or so, and perhaps longer, you'll get an acknowledgement and order just showing that the MSPB is acknowledging your appeal. So what I just mentioned is what's on this slide is that MSPB will notify you that your appeal has been received through an acknowledgement order. In my experience, these orders usually are issued within a couple days, but they have taken longer. So depending on how much information you provide the MSPB, just so they could confirm whether or not their order needs to contain any other requirements. For instance, there's potential that the MSPB may include a requirement that you show that there's jurisdiction over the appeal. So as far as jurisdiction is concerned, the MSPB may want to know whether you are an actual employee that has merit rights, has rights to appeal. The MSPB want to confirm whether or not you were timely in your appellate action. And so those orders, that language could appear in the acknowledgement order that you do receive. But the order will likely also contain an order regarding discovery. So a discovery period is a period of time for you to discover information to support your appeal, meaning discover information from the government agency. Now, the government agency that you're appealing the action from also can discover information from you, but it's overall called a discovery period. So both sides could try to develop information to support or defend the appeal. Now, the acknowledgement and order will have deadlines in place for you to serve discovery requests to the government to gather that information. And it's important to watch these deadlines and look at these deadlines. Usually it's about 30 days from your receipt of the acknowledgement and order. But the government also has those deadlines as well to serve requests to you. Now, these requests could take the form of written requests called interrogatories, or request for production of documents. You could ask the government to produce you documents such as email correspondence that you may have not seen between the deciding officials. If you're subject to a RIF, if you haven't received information regarding, where you ranked on the retention register or why you were selected in a certain competitive group, you would want documentation pertaining to that. And I think going a lot more along the RIF, you would probably want information about how they notified you or how they classified you as your performance ratings. You may see on your RIF notice that your performance ratings don't seem as accurate. So you want your complete file to confirm what ratings they used, including as well as just information about how they calculated your service computation day. I think that would be important. How they, like I just said, classified you as or put you into the competitive group, and how they confirmed you were an appropriate employee in that competitive group amongst other employees. I think that's also important information to obtain if you're not able to obtain it before you file an appeal. So that's why there's this MSPB process, because the judge could allow you to obtain that information. For normal removal actions or actions that aren't RIFs or other actions, there could be information you want to learn regarding how other employees were treated that face similar charges and whether they were removed or not. Like I said, you could seek correspondence that the deciding official, proposing officials relied upon to take the action against you. You could seek additional documentation for why the agency decided to remove you versus a lesser penalty. This is all information you could request from the federal government through discovery, where you submit written requests for documents, requests for admissions of facts even, and interrogatories as well. You could also take depositions, which are basically oral interviews of witnesses, where you ask a witness to appear and they are under oath, and you ask them questions pertaining to your removal action. And these are, not before a judge, these depositions, but that's your opportunity to kind of test what the agency official is going to say ahead of a hearing, and to test their credibility as well to see if they're consistent in making their statements. That's what the discovery period allows you to do. It's allow you to discover this information so you have enough information to go to hearing with if you decide to go to a hearing. If you ask the government for this information and they don't respond, you could file a request with the administrative law judge compelling them to respond. Again, the acknowledgement and order will contain specific deadlines for you filing this compel motion. So you should really look at that, and I would highlight all the deadlines you see in there and put it on your personal calendar, especially if you're not doing this with an attorney, just because you'll need to state, you need to track when the government is supposed to respond. And then when you get the responses, how long you have until you need to file that motion to compel. Please keep in mind, if you're in that situation that and you feel like you need to file a motion to compel, you are required to at least reach out to the government beforehand and try to resolve those disputes, resolve the issue of the government not responding before you file that motion to compel. But if you are able to file a motion to compel, then the government does have a chance to respond to that motion, and then the judge would order whether or not the government has to comply with the motion. One thing I skipped over in the acknowledgement and order is that the acknowledgement and order is going to set a deadline for the government to actually respond to your actual MSPB appeal. The government will have to submit a response. They submit what they call an agency file that contains a narrative response, contains the documents utilized to support the action against you. So a lot of the information you may be thinking you need in discovery may be in that agency file. So it's important before you serve those discovery requests to actually review that agency file and determine, well, what additional information do I need? Perhaps the government provides something or says something you didn't know about beforehand, and therefore you could create an additional question, about how they came to that determination. And that agency file is usually required to be submitted before you have to serve discovery request. Another important note here is if you are running up against a deadline, if these deadlines are happening too quickly, or if you don't get the agency file on time, you could request extensions. If the government is just not complying with your requests, if you're not hearing from them, you can not only move to compel, you could ask that they be penalized through sanctions. Now, I won't say that the judges will willingly issue sanctions. There has to be some conduct that just, that would be sanctionable, that they've refused to comply with orders or whatnot. So I don't hold your hopes for obtaining sanctions, but just know that is an option if you're facing a situation where, the government's not complying with your request unreasonably. So just to go on with the Merit Systems Protection Board appeals process. So after that discovery period that I described, then if you've chose to have a hearing, there will be a hearing that the judge will set. Oftentimes, the judge will have a status conference where the judge will call everyone on the phone and ask the parties to just confirm what the issues are, to confirm what the status of discovery is, and to ask when the hearing could be held, to make sure everyone is available for the hearing. If the hearing is scheduled, the judge will not only schedule the hearing, the judge will also set deadlines for a pre-hearing and set a date for a pre-hearing and set deadlines for pre-hearing submissions. So like I said earlier, the hearing is essentially an administrative trial where you get to testify in front of the judge, and agency witnesses and relevant witnesses get to testify. Well, before the hearing, there has to be a conference to determine who gets to testify, who is allowed to testify, what exhibits are allowed to be brought forward during the hearing, what are the issues in the case. And that's what the pre-hearing conference is. And before the pre-hearing conference, both parties are allowed to submit what they think, or who they think the witnesses should be, what they think the exhibits should be, what they think the issues are. And so there will be deadlines set up for submitting those pre-hearing submissions to the administrative law judge, and then a pre-hearing conference to discuss those pre-hearing submissions, and then the actual hearing. Now, the hearing can be in person or virtual. During the pandemic, almost every hearing, I believe, was virtual. But now, as of late, now the judges are allowing more in-person hearings. It's really up to the appellant, that's who the federal employee would be, to determine whether they want an in-person or virtual hearing. But if you want an in-person hearing, that could occur. If you want a virtual hearing, that could occur as well. Virtually, I believe the MSPB is still doing virtual hearings via Zoom. So that's how the virtual hearing would occur. At the hearing, you would be able to testify, and witnesses would be able to testify. You would be able to put in exhibits into evidence, and the agency would as well. Now, oftentimes the agency will be represented by an attorney, that the agencies employ attorneys to specifically represent them in these types of appeals. So there will be likely an agency attorney presenting to the judge its evidence through the witnesses they are offering. So as far as like what you have to prove at a hearing, if the action, it concerns your misconduct, if you were removed or reduced in grade or received a suspension over 14 days, then the agency has the burden to prove by a preponderance of evidence that the misconduct that they allege occurred. And this is the agency's burden to prove. And it's essentially means preponderance of the evidence means more likely than not that you committed the conduct. The agency also has to prove that there's a nexus between your conduct and the efficiency of service. And then, again, if this is concerning your misconduct, then the agency has to prove that the penalty, if the agency proposed a removal as a penalty or demotion, they have to prove that penalty is reasonable. And there are a list of factors that the agency will use to determine that, and those are called the Douglas factors. And that is the agency's burden to prove that. And you have the opportunity to rebut that evidence. If the hearing concerned performance, meaning you were removed for poor performance or unacceptable performance, the agency still has the burden of proof. They just have a lower standard of proof called substantial evidence. That they just have to prove that a reasonable person would agree with the action, the performance-based action taken against you. They do have to prove that the performance was unacceptable and that led to a performance improvement period and that it remained unacceptable during the performance improvement period. They also have to prove that they have a performance management system that's approved by OPM. But if they're able to sustain those or show those elements, then and you're not able to rebut those elements, then the judge may rule in their favor. Now, you do have the opportunity to show through either of those actions that the action was based on retaliation or discrimination, but that's called an affirmative defense, where you say, well, this action only occurred because of retaliation, or this action only occurred of discrimination, or there was a procedural error that was harmful. Perhaps that, and for example, in the procedural error, perhaps that you never receive the evidence pertaining to your proposed removal. That could be a procedural error if you never received it, because you wouldn't have an opportunity to properly respond. You have the burden of showing those affirmative defenses to show that these actions were taken for these reasons. As far as the reductions in force actions, the agency has the burden of showing that their reduction in force was within line with the regulations. And the regulations state that the agency can reduce their force if it's for reorganization, or perhaps because of saving money or business reasons. You then have the burden to show that they didn't follow regulations, whether or not they incorrectly listed you in the wrong competitive level, or you weren't in the right competitive group, or they didn't give you proper notice of the reduction in force action. I believe the regulations state on reduction in force that the agencies have to give at least 60 days notice. If you weren't correctly listed in the retention register, if essentially the agency didn't follow its own policies, and you were able to show that, then the judge could overturn that reduction in force action. Other potential arguments or other claims, like we've mentioned, are the individual right of action claims, where you have the burden of showing that you were retaliated against based on whistleblower disclosures. That is another claim that the MSPB does utilize, and you would have the burden there. I believe we have additional webinars through our firm that kind of explain those processes more. But I just wanted to kind of give a general overview of that process during a hearing. During the hearing, you or the agency, given that they have the burden of proof, in a lot of cases, have the opportunity to present witnesses first. But you will have the opportunity to testify, especially if you request to testify. At the end of the hearing, the judge will ask, and even before the hearing, the judge will ask whether you want to give a closing argument, which you have the ability to do. You could even request a written closing argument if you want. Now, that will be up to the judge's discretion about whether to provide that. There should be an opportunity for a closing argument, and the judge may opine and say whether the judge thinks there should be a closing argument or not, but that is something that could be discussed. During the hearing, the judge will explain the procedures. The judge will rule on witnesses. Given that it is like a trial, you have the opportunity to object if the agency attorney is asking questions to a witness that you don't believe are appropriate. You could object. Now, the agency attorney could object to your questions as well. During the hearing and before the hearing, and during this MSPB process, there will be discussion of settlement. And the judge will specifically ask whether the parties do want to try to settle. And that means agreeing to a resolution of the appeal, where you would agree to withdraw your MSPB appeal, and the government would agree to give you certain items that you request. Settlement can be done through a mediation. The MSPB does have a mediation appeals program where they have administrative law judges or MSPB officials that will hold a conference between the parties and mediate the claim to determine whether there's any middle ground, essentially, whether the government's willing to give anything in exchange for you dropping the appeal. And that process is available throughout the appeals process, including even during the hearing. I've had situations where there's, before a hearing started, the parties agree to go to mediation and eventually do settle. So just understand that is an option as well. So after the hearing, the judge will issue a decision. As far as when that decision is issued, that it could vary. The judges do want to process their cases within 120 days from the date you file your appeal, but that could be extended, and it is extended often because of just capacity of judges, just because there's additional discovery that is going on that requires extensions. But a judge will issue a written decision on your appeal after the hearing. Now, if the decision will state whether the judge finds in your favor or not. Essentially, it will state that the judge sustains the action. That means the judge agrees with the agency, or does not sustain the action. That means the judge agrees with you. The judge's decision will explain the reasons for the decision. The decision will also outline the ways to challenge the decision further if you do not agree with the decision, or if the agency doesn't agree with the decision. Specifically, you could file an appeal of the decision, the initial decision. It's called a petition for review, but it's essentially an appeal saying, I don't agree with the judge's decision. You could petition for review before the date the decision becomes final. So as you see, it's called an initial decision. So it's an initial decision because it's not yet final when the judge issues it. But the decision will become final by a specific date, and it will state that date in the initial decision. If you file a petition for review before that final date, then the decision is not final and it's being reviewed by the Merit Citizens Protection Board. Now, as I mentioned earlier, there have been some changes amongst the board. There's been, a board member that retired recently, and that's a board member that was fired, but I know that's being challenged. Currently the board can't issue decisions. So what an alternative route for employees, if they're in this situation, is they could file a petition for review to the United States Court for the Federal Circuit. Now, this is a separate court, and you file that petition for review after the decision becomes final. And you have more time, you have about 60 days from the final decision to file that petition for review with the United States Court of Appeals for the Federal Circuit. Now, the initial decision will give you the address. I think they even give you the website link of the court, because there are a number of courts especially in the DC area, and I know it sometimes gets confusing on which court to file. So they'll specifically outline where to file and who to file with if you want to take that route. But that is the ability of the court to review the decision of the MSPB and potentially reverse the decision if they deem it necessary. So some benefits of having an attorney, I think, through this process is An attorney could ensure that you're timely on filing your appeal, on meeting the judge's orders, on representing you at the hearing. I mentioned settlement. An attorney could also help with settlement, in negotiating with the agency in your best interest. The judge will, like I mentioned, definitely ask the parties if they want to engage in settlement, and that attorney could help you, navigate what the best settlement offer would be and whether, to accept or decline, given that settlement is always your decision. An attorney can help to advise you on establishing MSPB jurisdiction and replying to any orders that the judge sets out. Could help you go through those mitigating factors. I mentioned the Douglas factors. One other thing I didn't mention, but what can occur during the pre-hearing process are subpoenas. Sometimes there are witnesses that are not government employees any longer that need to be testifying at a hearing. Especially nowadays, given that there are several government employees that are taking deferred resignation offers and whatnot. Well, the MSPB does have the power to issue subpoenas to persons, especially former federal employees. And an attorney could help you with that process on requesting a subpoena be issued and issuing that subpoena so that witness could testify. I guess to be clear, current federal employees will have to testify. But if they are no longer a federal employee, even if they just retired, they're not required to testify, but the MSPB could issue a subpoena for that testimony. And an attorney could help you with that process. Okay, questions. I know we had a number of questions beforehand. I may have answered some of them throughout, but let me pull these up. One question we just received was, what is the best option if there's discrimination in a federal removal? This is a great question, and this is actually a complicated area. So there's another organization called the EEOC that has jurisdiction over discrimination matters. But if your question is, well, I was removed or demoted or whatnot, and I believe it's wrongful, but I also believe it's discriminatory, you do have the choice of going to the EEOC or the MSPB initially. Now, if you decide to go to the EEOC and it's really called going to the EEO office to claim that removal was discriminatory, the EEO office will investigate that discrimination aspect of your claim, but ultimately they'll give you a report of investigation and you'll have to go back to the MSPB. Meaning you could appeal that discrimination to the MSPB. So that's why I think it's actually more advantageous for you if you're facing a removal action to go to the MSPB, because the agency has the burden of proof to show that your removal was wrongful. And it's given us the agency's burden of proof that actually is an advantage to you. And you could still assert that your claim was discriminatory because you have that affirmative defense. Now that is your burden of proof, but that allows confirms that the agency does have that burden of proof to prove your action was wrongful. It also is quicker than having to go through the whole EEO process and wait for an investigation to be completed. So to answer your question, I would advise to go through the MSPB appeals process if you're facing a removal and you claim at the MSPB that your action was discriminatory. Another question was, can you file with the OSC and MSPB at the same time on a prohibited personnel practice? No. You have to go through the Office of Special Counsel before you file with the American Citizens Protection Board on your whistleblower retaliation claim. So that's why on that form they're asking when you received your final closeout letter and whatnot. Now, if you're filing a prohibited personnel practice, and this actually was happening a couple months ago or a few weeks ago when there were a lot of people that were terminated based on the probationary period. Now, OSC needs to file those claims if you're just filing saying, well, the action taken against me was wrongful or whatnot. But if you're claiming that I blew the whistle, I told my supervisor that there was fraud, waste, and abuse going on, the next day I was fired, you need to go to the Office of Special Counsel, make that claim. If they close out the investigation, issue a final determination letter, you could appeal that to the MSPB. As far as the RIFs, we got a question if you got an intent to RIF, but not an actual RIF. the timeline to file the appeal based on the RIF runs from the effective date. It does not run from the date you receive the RIF. So the RIF notice should say the effective date. Now, if you got an intent to RIF, it's not necessarily appealable. Now, maybe there's another form you could, if you believe it was discriminatory or whatnot, you could go to the EEO office, but that's not an appealable action if you haven't actually been RIFed. So we got a question regarding just the violation of civil rights via EEOC complaints. I'm not exactly sure what that question is pertaining to, other than, if you believe it's discrimination, you would file with the EEOC directly. That's something that you could file with the EEOC. And there's different jurisdictional requirements of the EEOC. It depends on the type of claim that you're actually alleging, because there may be an opportunity to even bypass the EEOC. But as far as filing union grievance in the EEOC, that depends on what type of employee you are and what agency you work with, whether you could do both. In general, you may not be able to, but that's somewhat out of the scope of this webinar. So a question that was just asked, and a question that was actually pre-submitted, is, well, basically, how backed up is the MSPB? Is this going to take longer and longer? Theoretically, it could, given that there are a lot of RIFs going on. I think what the MSPB may be willing to entertain are what they call mass RIF appeals, where essentially appeals by employees that are taken for the same reasons within the same agency. The MSPB can consolidate appeals and could adjudicate appeals through a consolidated appeals process, which may quicken what is anticipated as the influx of appeals. But currently, from my practice, the judges are still processing cases as they have been, and there haven't been any slowdowns that I've seen. But I understand that may change, given that there are going to be more appeals. But again, the process is for a judge to complete the process within 120 days. Again, that sometimes, and a lot of times, is extended, by an additional time for various reasons. But I think in most cases, without extensions, you're getting into a hearing within about 6 months or less. If you filed a grievance, or if your union filed a grievance on your behalf, you would check the box yes on that form. That was just a question that we just received. So we just received a question about filing an MSPB appeal before filing a motion to compel. And yes, you do have to file an MSPB appeal. I understand, regarding the RIFs, that you're asking for this information and no one's providing it. And that is something that you could obtain during the MSPB appeals process, but you do have to file that appeal. We represent clients where we're trying to get this information as well. And if the government's not giving that information, take it to the MSPB, and then try to get the information that way. So we're getting a lot of questions, and you're actually in the pre-submitted questions, just about what the government has to provide prior to the actual RIF becoming in effect. Again, I know a lot of people receive these RIF notices and they're asking for all this information. The government is obligated to comply with the RIF procedures. I don't know of any specific requirement to or compel a way to compel the government to provide this information currently before an appeal is processed, before an appeal is made. I would encourage you to still request it and state why it's needed, and to even make arguments about why you believe you may not have been put in the correct competitive group. But if that's ignored or not provided, then I advise to file that appeal as soon as possible and request that information as soon as possible. Because the government has the burden of proof to show that it complied with the RIF procedures, so they will have to get that information at some point. The time frame to submit with MSPB is within 30 days of the effective date of the action. The appeal needs to be submitted online. Now, if you don't have access to an online form, I believe the MSPB does receive the appeals via fax. And they may even receive it via mail. The easiest and quickest method is online. but I understand that if that could be difficult, they do provide fax numbers. It's right on the MSPB website that we provided earlier in this presentation. I believe I answered a lot of the questions that were pre-submitted. Again, a lot of them had to do with RIFs, impacts of RIFs, the time frame of RIFs, how to get the information. So we just received a question about being classified as Schedule F and any due process appeals rates. This is a good question. Actually, during the Biden administration, Biden did, there was a rule that was finalized that allowed people to challenge their classification. I don't have the regulation offhand, but there is a way through that regulation to challenge that classification. If you're classified as Schedule F and you don't believe that's appropriate, there are rights there to challenge that regulation. So we're getting now questions about just, well, how much does it cost to retain an attorney? How do you find an attorney? What I will say is we offer consultations, and our contact information, I think, was at the beginning of this slide or this PowerPoint. We offer consultations where we could discuss an appropriate retainer, for you and for your situation. I can't give any specific quotes because it depends on the specific situation, but I encourage you to contact our firm, to discuss your matter through a consultation, and then we can provide you the appropriate retainer for your MSPB appeal. As far as our consultation fees are $150. Okay. I'm not getting too many other questions. Again, I was trying to cover everything that was pre-submitted. It seemed like a lot was covered through the RIF discussion. If you have further questions, I encourage you to reach out to our firm. Our contact information is there on the screen, and we could discuss your situation through a consultation, discuss the right path to move forward, and provide you a retainer agreement if deemed appropriate. But again, my name is Michael Fallings. I'm so happy I could speak with you regarding these issues, and I hope to help you out if needed on your particular situation. But thank you for joining us.